The next session is session 4, Recent Developments in ASEAN Law. The chair of the session is Professor Jayakumar, who is Senior Legal Advisor to the Minister of Foreign Affairs of Singapore. He chairs the International Advisory Panel of the NUS Center for International Law. He was Singapore's former Deputy Prime Minister and Senior Minister. He also served as Minister for Home Affairs, Minister for Foreign Affairs, Minister for Labour, and Minister for Law. He was a permanent representative to the UN and High Commissioner to Canada. Before his political career, he was the Dean of the NUS Faculty of Law. Without further ado, Professor Jayakumar, over to you.
I want to welcome everybody to this panel, which is on recent developments in ASEAN law. But as chairman, I've taken the liberty to broaden the scope, not just to ASEAN law per se, but rather ASEAN and developments in international law in the past 2 years since we last had the Conference of the Year in Review. We have 3 very good panelists, and let me just introduce them. Professor Simon Tay, who wears many hats, including the chairmanship of the Singapore Institute of International Affairs. Then we have Dr. Tan Hsien-Li, who is CIL's co-director for the program on ASEAN law and policy. And the third panelist is Professor Tony Anghie, who is head of CIL's TRILA program, TRILA, which, for those who are not familiar, is Teaching and Research of International Law in Asia. So 3 excellent panelists, and given the time that we have, and considering there are so many aspects about ASEAN that we can talk about, the panelists will pick up, I suggest the panelists pick up 3 strands. Probably Simon Tay can kick off with his general overview of how ASEAN has risen to recent challenges, momentous challenges in the testing period that we have seen. Perhaps he can speak on Myanmar, which has been a very big issue, just touched upon in the previous panel. Not Myanmar per se, but perhaps on the broader implications for ASEAN, principles of non-interference and the tensions with matters of international concern, not only a regional issue, but an international issue. And for Dr. Tan Hsien-Li, perhaps she might want to talk about ASEAN's response to perceived fragmentation of the world order, challenges posed to the multilateral world order, and how has ASEAN coped? Have we seen a retreating inwards, or is regional cooperation still very much alive? And Tony may I suggest that you might want to pick up the ASEAN and the language of international law, especially in the context of recent years where there's been a perception, especially during the Trump presidency, of giving lesser importance to international law, as it were. And also, perhaps you can talk about the importance and present state of training of international lawyers in Asia, which is very much within ASEAN's core interests of, and has special programs for this. So can I ask Simon to please kick off first?
Thank you, Prof. Jayakumar. I understand I have about 8 minutes. I'll try and cover the points you've given me. But first, allow me to start by saying what an honor it is to be on this panel. Thank you, CIL, for inviting me, and especially if I have Prof. Jayakumar, who was Dean when I was first admitted to law school, and also the Foreign Minister for Singapore when ASEAN faced the Asian crisis. And he really helped sort of reshape ASEAN at that time. And in fact, today I'll argue we're probably at that stage again. I'm also very happy to be here with Tony, who was my classmate at Harvard and now my colleague at NUS, and of course Hsien-Li, who studied with me and now is also a colleague at the NUS. So please allow me to start by setting out a context. I'm aware that many of you are not from ASEAN countries. For us in ASEAN, ASEAN is always important, but why should ASEAN matter to those interested in international law? And basically, I'll try and frame it, as Prof. Jai said, not so much about the treaty and cases, because there aren't that many, but really about the institutions, the processes, and the norms of international law. And ASEAN has been a regional bloc, how it sits between the national sovereigns and the international community. And so roughly that's the framework I'll try to bring. And as Prof. Jaya has asked me to do, I'll talk about 3 issues. First, the pandemic. Second, Myanmar. And third, the haze, which is relatively a good story. But remember, I'm trying to do this so that we can understand how this regional bloc tries to play and work on the norms of the international community and how it influences the national governments. On the first issue, the pandemic, I think really there's much more to be said, but the struggle globally is very real. There has been a real pressure on the rules of trade, of travel, and a certain sense of committee in terms of trying to keep those relationships stable and resilient despite the pandemic and the sense of public security and urgency, which the earlier panels talked about. Now, within that context, and also the context of the Sino-American tensions, I think ASEAN actually did very well. In the early stages, when Trump was still in the White House, the appeal of China was very strong. And the first ASEAN summit on the pandemic brought in China. But the second also brought in the Northeast Asian 3, the East Asia, South Korea, Japan, and China, to really multilateralize the hope of cooperation and linkage. I think ASEAN did well to do that, and in a sense, constantly reinforce the need to make this really not just a regional approach or China plus one approach, but really a larger region and global approach. Similarly, as the pandemic has worn on, the ASEAN efforts to relate to COVAX, to come up with our own schemes internally, have culminated in ASEAN Summit, as well as ASEAN's efforts to raise the issue in terms of a comprehensive recovery from the pandemic. Now, that was at the end of last year. Since then, this third wave or fourth wave or whatever wave we're having has really surged in the region. And I must say that as an analyst, we see it going back to national governments. But given what Ayelet Berman said earlier, I think we cannot expect otherwise. If a body like the WHO, built for pandemics and other health problems in the world, cannot fully respond to displace what national governments do or do not do, I would say that ASEAN can rise a certain level to the challenge, but in the end, it will be up to each of the 10 countries. On that relatively low bar, I think ASEAN has played a decent place as a regional player. The judgment on the next issue of Myanmar, I think, must be slightly more severe. It is a good sign that ASEAN has brought this issue to the table, again has held a summit. But there again, after that, the questions of what ASEAN more can do have been exposed since the summit. Now, the summit, I think, was highly successful. Our country, Singapore, together with Indonesia, a true democracy, and Malaysia, have been at the kind of cutting edge to try and bring this issue quite resolutely, I wouldn't say the word forcibly, resolutely to the table with our neighbor, Myanmar. And to do it in a way that puts us in a way at the front end of this problem, rather than delegating it to the major powers or to the UN. In fact, while the UN has appointed a special envoy, this special envoy has had no remit to go actually into Myanmar. And I think in that sense, ASEAN again has acquitted itself relatively well. But where it's fallen short is, of course, that the solution, if there is to be one, about what's happening in Myanmar depends on the key actors there. It's a question of national politics and the remit, especially of the Tatmadaw, to pull back from its use of violence to settle its internal politics and conflicts. There, I would say that ASEAN has yet to find a solution. But we are about less than 6 months into the problem, and I haven't given up that ASEAN will try. We can talk about this more later, but I think here, the norms have shifted. ASEAN in the past really would have taken a much longer time to even bring it to the table. ASEAN's use of human rights and democracy, and Hsien-Li teaches and works a lot in this area, is a relatively new invention since the ASEAN Charter and the years before that. And I would say, and I'll return to this point about the Charter, we're seeing an evolution of ASEAN's own norms of the balance between non-interference and the need to take issues, transboundary issues, human rights issues much more seriously, so the group, as a whole, can really deal with them more a question of dialogue. And that brings me to my third point about the haze. Now, here is a relatively good story. My think tank and I yesterday forecast that this year is unlikely to see a return of severe transboundary haze. Now, the roots of the haze, just like the roots of the Myanmar problem, are national. They relate to fires in land and forests in Indonesia. For decades, this problem has bedeviled the whole region, and ASEAN has put forward a treaty. For years, though, Indonesia, the epicenter of the fires, did not ratify that treaty. And so we were left for a time very incoherent, having tried at ASEAN level to push forward a treaty, put forward norms, but without the buy-in of Indonesia, really ineffective. Well, what has changed is that Indonesia, under President Jokowi, has made the dramatic effort to realize that it is actually Indonesia that suffers the most, and it's Indonesia's national interest to join in the ASEAN-wide effort. And this effort really is, of course, again, the epicenter of the problem, but it demonstrates how ASEAN can help the process of shaping those norms. And Singapore and Malaysia, which also are involved in either the trade or production of palm oil and pulp and paper, two of the products involved in the fires, I think have played a useful role. As a result, the Southeast Asian ASEAN fires are much more controlled than the problems that are emerging in Northeast Asia. More on that, these problems have now been linked increasingly to the global climate change issues, which again, an earlier panel talked about in the law of the sea. So I think in this sense, ASEAN has played a useful role to connect the national norms with the global norms.
Apologies, Simon, you have a minute left.
Yeah, thank you, Sarah, my last minute. This is that the ASEAN Charter, which Tommy Koh, who's also on this call, helped bring together after an eminent group, Professor Jayakumar was involved with, brought the issue to the table, is a working document. It contains a lot of the norms and institutions of the past when ASEAN was much more diffident to national sovereignty. In the years since the Charter was done, we've actually talked much more strongly about ASEAN community, economic, political, and also social-cultural. It is probably time that the ASEAN Charter will have to be relooked. In these three instances, we see one positive story, but there are other stories about the norm of non-interference, about suspension of membership, and the rights, but also the responsibility of the chairman and other members to bring issues to errant states. Please allow me to stop here. Thank you.
Thank you, Simon. Can I ask Hsien-Li to take the floor now?
Okay.
Hsien-Li.
Thank you. Thanks, Prof. Jaya. Hi, everyone. Good afternoon from Singapore. So it's been 18 months into the pandemic, and I think it seems like the international order has gone a little full circle. We thought that, with vaccinations, with the new Biden presidency, perhaps the world order would revert to one with less tension. There would be a resurgence of multilateralism. But as Simon has pointed out, there is, rising unilateralism again. And I would also like to say that, when we see this rising unilateralism, and in the pandemic year that we have seen, there is rising inequality in this international order. So with all this, tension going on, what is there for us to do in ASEAN? What do developing states see as their place in this international order? And the answer really seems to be multilateralism. So multilateralism has been ASEAN's song forever, right? Depending on some time, sometimes members might go off on a tangent, but overall ASEAN projects, multilateralism is good, and multilateralism in the international order is a good one. This seems to be the song in the Asia Pacific, in the wider Asia Pacific. So let me share my screen with you, where the most recent APEC report about 2 weeks ago, it says multilateralism in the era of COVID-19. And the survey wasn't only, about states. The responses came from more than 7,000 participants over the Asia Pacific, including ASEAN member states. And 84% of the respondents said, multilateral cooperation rather than competition is important, right? And because many of us in the Asia Pacific are developing states, and given the inequity in the international order, cooperation is important, right? And 71% think that multilateralism rather than, self-dependence or unilateralism would aid their country's recovery and, their personal economic development in other circumstances. And what the other responses saw was that the top 3 challenges that we have seen in the past 18 months and also projecting forward are global politics, protectionism, rising protectionism, and fake news. So where do we see ASEAN's place in this, right? Multilateralism is important. So there are 2 threads to multilateralism. One is intra-ASEAN and one is ASEAN vis-a-vis the rest of the world. So let's look at intra-ASEAN multilateralism, the ASEAN economic community, its economic integration. So economic integration really started after the coming into force of the Charter in 2008. And since then, the projection has been for the last 5 years that there would be an annual growth of ASEAN GDP by 5%. In the most recent midterm review of the ASEAN Economic Community, so looking at 2016 to 2020, and the report was just out in 2021, we see that kind of 50% of the sectoral work plans, all the plans to make sure that the ASEAN Economic Community is robust, half of them are being implemented. So 50%, it's good, but it's really not good enough. Right? It's really not good enough. And in the past 18 months of the pandemic, world economies have slid and the ASEAN GDP has fallen, and it has fallen by 3.3%. We were looking at a growth of 5%, now we're sub 3.3. Tourism fell by 82%, and we know that is such a hard hit because so many of our economies are tourism dependent. Trade, okay, not so bad, fell by 7.4%, but foreign direct investment, where our ASEAN economies, we are dependent on FDI, that fell by 33.2%. So very, very significant. And this is the reason why multilateralism is so important. So intra-ASEAN cooperation, economic integration, what are the key areas? There is no magic bullet. What we have been doing, we need to do more. So from the midterm review, and this is what the economists and lawyers, policymakers have, they have honed in on these points. First, we need to lower non-tariff measures, non-tariff barriers. Although we have an ASEAN free trade area, so 0 to 5%, tariff rate, but the non-tariff measures are still very high. So these really have to be eradicated. So step by step, lowering these barriers. The other one is to make sure that intra-ASEAN trade or, trade coming into ASEAN and goods moving within the ASEAN bloc, the pathways are smoothened. So we have kickstarted at the end of 2019, the electronic customs form. So you can think that, oh wow, it's really only 2 years ago that we in ASEAN started, using electronic customs forms. Yep, that's the truth, right? And that makes the flows much easier, the trade flows much easier, less bureaucratic paperwork. What else is there on the cards? To expand this, digitalization for trade and services and investment within the ASEAN bloc. So now we come to digitalization. This has been on the ASEAN economic agenda for some time, right? For the last 5-10 years. But COVID really brought this to the forefront, and we need to kickstart it seriously. It is not easy, as Mr. Lionel Yee pointed out. There's inequity. So digitalization is not cheap. You need investment, you need infrastructure, you need human resource training, and you need to equip, the general population on the usage of it. right? Small, medium enterprises also need to be part of this digitalization process. So depending on how developed your economy is and how much investment there is going to be in these areas, we will wait and see, because we are really only ramping up digitalization right now. What else is there? So continued action, non-tariff measures, improving and hardening the law from declarations to treaties, and moving into greater multilateralism. So I will share my screen and end off there. From here, we are looking at greater, apart from intra-ASEAN integration, ASEAN is also focusing on external relations, external economic cooperation. So it's not external economic integration, it's external economic cooperation. And you can see the bolded countries are ASEAN member states, and we have the Regional Comprehensive Economic Partnership, which is the ASEAN member states with its 5 dialogue partners from the Asia Pacific minus India. And then there is the Comprehensive and Progressive Trans-Pacific Partnership, which is a mixture of some ASEAN member states, some ASEAN dialogue partners like Australia and Japan, and Canada. Oops, I should have put Canada in, but Canada and some Latin American states, right? So how does this work? These huge multilaterals, they are supposed to lower trade barriers and increase, the economic development, investment, so on and so forth, and also the movement of services. So let me give you a figure. They are supposed to bring in, CPTPP is supposed to increase, world real income by 150 billion by 2030, and RCEP adds another 186 billion. So that's very considerable, to the world economy, to ASEAN economies. But there are obviously caveats, right? Because what are we looking at in terms of implementation, right? And also there are kind of outliers, new members to these multilaterals. China and the UK expressed CPTPP interest. Hong Kong wants to join up to RCEP, and China is supportive, right? Will India come back to RCEP? And also, of course, there are going to be other competitors, right? Not really multilaterals per se, but kind of bilaterals, but along, the Silk Road, which is the Belt and Road Initiative and the G7 Build Back Better World Initiative, which is only on paper now, and needs to be, fleshed out. So that's all for me.
Thank you very much, Hsien-Li. Can I give the floor to Tony Anghie now? Tony.
Thanks very much, Prof. So I'm very honored to be on this panel with Prof. Jaya and my friends and colleagues, Simon and Hsien-Li. And I'm also very grateful to Simon and Hsien-Li because they are experts in ASEAN and I am not. And so they outlined very clearly some of the most important recent developments in ASEAN. Prof. Jaya invited me to say a few words about perhaps some of those developments in a broader context. One of the interesting developments in scholarship on international institutions and so forth is a recent focus on what might be called regional international law. So in the midst of all these other developments, turn towards nationalism, a turn towards sovereignty, what is really interesting is how international law might be more effective if it is made within a regional context and made in a way that reflects the needs and aspirations and the common culture, really, that we hope exists within those regions. So we might think about Africa in that context and various African institutions, and we might think about ASEAN in that way as well. And as an outsider who is not particularly familiar with ASEAN law, what strikes me is something of a gradual shift away from what might be called emphatic vision of sovereignty to an understanding of sovereignty. Hsien-Li already mentioned this understanding that multilateralism is important, and Simon has talked about the haze and the different efforts, successful efforts that have been made to deal with this problem. So we can see this evolution gradually taking place as well, which is, I think, very encouraging. So having said that, I thought I would talk a little bit about, or spend the rest of my time talking about a program at CIL, which doesn't usually get very much attention, but which also in a way focuses on developments within ASEAN. And that is the program that I'm involved in, called Teaching and Researching International Law in Asia. And we might ask the question of, why does this program exist at all? So it's very interesting to note that there are very few, you could say, centers of international law. If you think of the Lauterpacht Center or the various other centers that are located all around the world, I can't think of any easily which have a focus on the teaching of international law. And so we might ask the question as to what, why this exists within the Center for International Law. And I suppose a couple of reasons could be given. So the first would be, if I can share my screen successfully. Well, it is within the mission statement of the center to become a regional intellectual hub and thought leader for research on and teaching of international law. So I suppose as lawyers, we want to find enabling language, and that would be the language that I point to. But I think there's another more compelling reason, which is to think about the importance of teaching for all the other projects that the Center for International Law is involved in, and all the other projects that we hope and aspire will be achieved by Asia in the long term. So you could say the larger project is the project of creating and participating effectively in the international system. And this has historically not been the case, because historically, Asian countries have been regarded as law takers rather than lawmakers. At a more personal level, let me just cite something that a scholar and you could say a prominent international lawyer had to say about his own education in international law. So I'm reading here, and this person says, "The course I took on international law was not well taught. It was taught in a very didactic manner. It focused too much on the learning of black letter law. There was no attempt to relate the law in the book to the real world in which we lived. The course was not exciting and challenging. I was so disenchanted that when I went to Harvard Law School, I did not take any courses in international law, even though I became acquainted with some of that law school's legendary teachers in international law." So some of you might guess that the person who said this is Professor Tommy Koh. And I think it shows sort of vividly the importance of teaching international law. Just think, as a result of bad teaching, we might have lost Professor Tommy Koh. In fact, I thought maybe that should be the title of my talk, Losing Tommy Koh. In other words, teaching does play a very important role in inspiring future generations of teachers in this way, and international lawyers in this way. So what does TRILA do? I'd like to claim that there is what I would call a Singapore tradition of looking at this whole question about teaching international law. In 1964, a conference was held here in Singapore, and it was attended by people like Myers McDougall and Boutros Ghali and a number of other very prominent international lawyers. And the focus of that particular conference was on the topic of how should emerging Asian states actually teach international law. And it looked at the importance of international law for the future of the countries of Asia as they emerged after decolonization. There was a very clear understanding that international law was a crucial part of the future and well-being of these countries. And I should also mention that a young graduate was the reporter of this conference, the special rapporteur of this conference, and that young graduate was Professor Jayakumar. So you can see how Professor Jayakumar and Professor Koh have both, in a way, been very important to this project. And so there have been a number of conferences dealing explicitly with the issue of teaching international law. And I would claim that this creates what I would call a Singapore tradition. Singapore was focused on these issues more than 50 years ago. We held a conference in 2018 which revisited these issues because we wanted to get a sense of what is the state of play as far as teaching and researching is concerned. And we looked at these particular themes. So we looked at themes such as the materials to be used for teaching, the creation of a syllabus, what sort of techniques would work more effectively, and particularly this whole new challenge of researching and writing international law, because what we sensed was that research and writing has become extremely important now in many law schools, and young faculty face the challenge of writing for publication in an international context. So what have we done? So having got that information, we published a report, the 2020 TRILA project report, which looked at what emerged from that conference. And that gave us, you could say, guidance as to the key issues that were of concern to scholars in ASEAN. And based on that, we've developed a number of programs. We call it TRILA on the road. And basically, this involves members of CIL, as myself and the other members of the TRILA team, well, the one other member of the TRILA team, going to countries like Cambodia, Sri Lanka, Myanmar, and so forth. And what we do is we say, well, here are 10 different issues or topics that we can deal with. We can deal with teaching techniques. We can deal with, any of these issues, building a course outline, scholarship, or what sort of textbooks, do a survey of the textbooks that are available. And what would you like to do? So in this way, it's a very active collaboration between CIL and also our local partners. And so this gives a different dimension as well to CIL's activities, because here we go out to those particular countries when that at least was possible before the pandemic. So we went to Cambodia, we went to Sri Lanka, we went to Myanmar, and unfortunately after that the pandemic stepped in. And so our programs in Indonesia, Malaysia, and Vietnam were all done online. So basically, all I can do at this point of time is to sort of suggest that you have a look at our website to get a sense of the types of activities that we have been engaged in. And the other thing I want to say is that I see this as being, certainly we have been focusing on ASEAN, but I'm convinced that what we do here in Singapore has global significance. And in other words, within the world of international law at this point of time, there's a huge interest in this question about how do we teach international law? How do we understand the changing circumstances facing the international community, and what sorts of materials should we use? What sort of techniques should we use? So for example, BICL, the British Institute, recently held a conference on dealing with issues of teaching, including teaching international law in the Arab world, decolonizing the teaching of international law. So there's a whole initiative, and it is a global initiative to look at the question of decolonizing the teaching of international law by using materials from outside European sources. And what I would claim here is that CIL is already at the forefront of this, when we're not looking to other places and what they do to inspire us, because we see ourselves at the forefront. We've started this program going back to 1964. And so I hope that would be something of interest. And I just want to mention some of the other things we have done at CIL. We've posted syllabuses, we've posted reports about the programs that we have held. And recently we launched a database of Asian cases and reading materials so that scholars all over Asia at least have a database that they can rely on to get Asian materials, because it is by using Asian materials that they can engage their students more effectively. So those are just some of the comments I would like to make about the TRILA program. And if you're interested, please have a look at our website and our social media. Thank you.
Thank you, Tony. And also thank you for that very interesting snippet about Tommy, my good friend. And also for reminding me about the conference, the Roundtable of Teaching of International Law, which took place almost half a century ago. We have time to take a few questions. I see that there's one from Eva Johan from Indonesia, which says that, I think this is for Hsien-Li, if you might take it, Hsien-Li.
Yes.
What do you mean by hardening the law and its relation to ASEAN way approach? Whether ASEAN does not have an ASEAN law legal system such as EU, So you might want to take this opportunity to answer that question.
Okay, thank you. Thank you very much, Prof. Jaya, and also from Eva. So basically, as everyone knows, in international law, you have hard law, which is treaty law, binding law, and you can go to courts for it, international dispute settlement. And international law also has a body of soft law like declarations, you know, some memoranda of understanding, so on and so forth. Some concords are also, you know, soft law in nature. So they're not binding, but they are, you know, expressions of commitment. So in ASEAN, because we first started as a political organization that was really, you know, geared to peace and security in the region, and there has been, but then now we are really turning our focus also to economic cooperation and economic integration. So there has been a hardening of the legal system of ASEAN, or, you know, or ASEAN laws. And so we're using more treaties right now. And more treaties are being used, especially in the ASEAN Economic Community. But at the same time, there are blueprints and sectoral work plans, which are very firm commitments, and they fall into the band of soft law. So what the policymakers want to do is to make these very firm commitments binding law, you know, in future. And also for the new commitments coming up, there will, you know, soft commitments turning hard, and new commitments not starting out as soft law, but starting out as treaties. Yeah.
Thank you, Hsien-Li. There's another question probably arising from what Simon talked about, ASEAN and Hayes. And the question is from Chan Se Wei from Singapore. Would the panel be able to comment on how, quote unquote, the good story of ASEAN's response to the Hayes issues might serve as a model for a response to looming environmental and agricultural tragedy in the Mekong River? Simon, would you like
Thanks, Prof.
to take that up?
Thank you. I read the question. I thought it was a very interesting one. First, I would say that the ASEAN will always struggle between three basic goals. One is the unity issue. A group of very diverse countries together is difficult. The second is the centrality issue, that ASEAN needs to try to be a central player, not just for itself and 10 members, but the broader region and its various partners, and whether it's politics or environment or economics, which Hsien-Li mentioned. And the third is effectiveness, and not necessarily all three can be squared. Sometimes in issues you will face disunity if you try to be too so-called effective, and sometimes you do end up with the suboptimal decisions and outcomes. And using so-called hard law processes may actually create more disunity. So I think these are very important, broad points to make, to bring to any issue, including analysis of, say, the Mekong. So, you know, one of the key differences between the Mekong and the Southeast Asian Southern Haze is that the main actor, so to speak, on the Mekong is China, who is not an ASEAN member. And though it's pledged to have this common destiny, etc., its interest in using the Mekong as for its power generation and other influence and benefits is very clear. And the second is, of course, that the alignment of China's interests with a number of the neighboring states, at least at the elite level. So with Cambodia, with Laos, they've tended to welcome these Chinese investments both at the river and broader. In fact, this has been one of the question marks about the continuing unity of ASEAN. So the complainants about the Mekong in that sense are not unified. In comparison, as I mentioned earlier, I think Singapore, Malaysia, and to some degree Brunei were early sufferers of very intense haze. And you know Singapore, though diplomacy like Prof. Koh and Jayakumar are very diplomatic, they are also very persistent. And the persistence and the national interest of Singapore, I think, has really helped drive that continual process of bringing the issue to the table. Even under previous Indonesian administrations, which were not keen, they were somewhat sensitive. But the key change was that dramatic change within Indonesia itself. Now, coming back to the Mekong then, can we see a China which would care enough about the environment and the results on the Delta countries like Vietnam, that it would forestall the benefits it gets, or somehow square the circle to have both some of the benefits, but to be more mindful of the environmental negativities. But the key issue first is to keep putting the issue on the table. Somebody in the Mekong or somebody interested in Mekong must, without being confrontational, keep bringing the issue to the table, as more than a generation of Singapore diplomats and policymakers now have with the haze issue.
Thank you, Simon. I see an array of questions coming in. Tara, how many minutes do we have?
We have 3 minutes, but I think Prof. Koh, did you want to say something?
Could I just make a very brief intervention on the Mekong River?
Tommy?
Yeah, I've done some work recently on international rivers and international law. So with your permission, I just want to make a few points about the Mekong River.
Please.
The Mekong River is one of the great international rivers of the world. And there is a legally binding agreement called the Mekong Agreement. But unfortunately, China and Myanmar are not parties to this agreement. So I want to make an appeal to China and Myanmar to join the Mekong Agreement so that all 6 riparian states are party to this agreement. My second point is that there is a UN Convention on the law of the non-navigable uses of international water courses. But unfortunately, very few countries have acceded to this convention. And of the 6 riparian states of the Mekong River, only Vietnam is a party. And so the convention is not binding on China, it's not binding on Laos. But there is an important international Court of Justice decision. And what the court said applies to the Mekong River, which is that the riparian states of an international river share a community of interest. And the upper riparian states do not have absolute sovereignty over the river. They must take into account the legitimate interests of the lower riparian states. So my point here is that China and Laos, the 2 upper riparian states, cannot unilaterally build dams on their stretch of the river and not worry about the effect downstream. What's happened is that China has built 11 dams and Laos has built over 50 dams. And it has a devastating impact on the 60 million people who live in Cambodia and Vietnam.
Thank you. Unfortunately, we have reached the end of our time. There are some interesting questions which really are directed at what Tony said about TRILA. So, for example, do you need CIL's permission to use some of the material if any of the professors wants to revise the curriculum, and what is the next plans for TRILA? So perhaps, Tony, you might in the chat give your contact or the website where these participants can pursue their queries with you separately. Thank you. And may I then wind up this program by thanking all my distinguished colleagues on the panel, and also for the active participation by other members on the Zoom, as evidenced by the many questions. Thank you very much.